All right, it's hard to relate this one to worldview. I can do it, but I won't bore you with that. This whole executive versus judicial branch issue that you're commenting on almost daily, Trump versus the district courts, what's going to happen there? I love the way you're commenting on it. I think you're dead on. So I'm asking more for what's going to happen over the next year.
Well, as usual, rage is taking us in the wrong direction, right? You have some members that are calling for the impeachment of these federal judges, which I have written strongly against. This is not something for impeachment. These are differences of interpretation. The fact is the Trump administration is using a controversial law from the Adams administration period in an extremely novel way. And district courts have disagreed with the administration. There are good faith disagreements there. And it'll be worked out in the courts. You don't impeach judges because they adopt different interpretations. I think these judges are wrong in many of these cases. I think that some of the initial rulings on DOJ and changes being made by the administration are manifestly wrong. I think that they are overextending themselves in Article 3. The president is allowed to reduce government. The president is allowed to look for fraud and waste. I think that these judges are way beyond their brief on this. And I think ultimately the administration is likely to win on one of those cases. But that's not uncommon. When Biden came in, he basically eradicated every one of the Trump executive orders. That is fairly common. And what happens is you have a sorting out. It goes through the courts. Presidents win some, usually most, and they lose some. Now, where I think the administration has a particularly valid grievance is on national injunctions. The fact is that these district judges have gone injunctive crazy, and this has been a complaint by both Democratic and Republican presidents. They view this as type of Lilliputian attacks. You got over 600 district court judges issuing national injunctions. You do the math, you do the implications, you can't run it. It's like having a jumbo aircraft and every passenger wants to take the controls. Someone has to land the plane, right? And in this case, the pilot is the president. And it's not just conservatives that have objected to this, not only Democratic presidents, but liberal justices. Like Justice Kagan recently said, look, this is insane. We can't do this. We can't have all these judges issuing national injunctions. So the Supreme Court has been largely spanking district court judges, hoping they'll get the message. They haven't. The number of national injunctions have increased despite their warnings. They've done all these shots across the bow, so now the Congress is looking at it. I think that there should be some changes. The things that I want to be cautious on this, that there are some cases where national injunctions are appropriate. If you've got a national class action, how are you going to limit that to the district, right? So you have to allow for that. What I would like to see is for national injunctions to be required to go to a 3-judge panel, a separate panel from that judge, that are given very narrow guidelines of when this is appropriate. To have the approval of those judges. And then I would also fast track it. Part of the problem for presidents is that temporary restraining orders are usually what are issued, TROs. Those generally go for 2 weeks. Many people believe that they are not subject to appellate review. There's some debate about that. 2 weeks is a lifetime for a president if that TRO is dealing with something of great national significance. And at the end of it, then maybe they have a preliminary injunction, which you can then appeal. I think it'd be better to have a fast-track system to allow a president to get this immediately before a higher court. Those would go a long way in recognizing legitimate objections from presidents. It's not that they're right. It's just that what they're saying is, look, I have Article 2 powers, and that requires me, of all the branches, I'm required to move the fastest, right? With Congress and the judiciary, all of the limitations are actually to get them to move slower, right? They're all designed to force compromise and consideration and deliberation. It's only Article 2 that is designed to operate fast because a president needs to be able to react, and then often Congress has a chance to respond. So I think that they do have a valid point here.
There's really so much that the founders could not have anticipated. that needs revision. And this is one of the big areas. It's almost like we need another constitutional convention to revise it like they did between the Articles of Confederation and the Constitution itself.